the beginning of really a tour at a series of different law schools at the University of Texas, Santa Clara Law School in California, University of Pennsylvania, Cardozo Law School in New York, I think the University of Arizona Law School, a series of law schools and a series of places across the country to join with our colleagues in the community of prosecutors, judiciary, the bar disciplinary groups, to address an extremely serious, complex, and difficult problem. And that is, how do we remedy and prevent misconduct by prosecutors in criminal cases? And the occasion for all this, and you will hear from him today, is John Thompson. John, as you all know, was framed for a murder and a robbery that he did not commit in Orleans Parish, Louisiana. He was convicted and sentenced to death. The misconduct that brought this about, as John will explain to you, was revealed. His conviction on the robbery and the capital case was reversed. He was retried on the capital case, acquitted in 25 minutes, then brought a lawsuit about a custom, pattern, or practice of not disclosing exculpatory evidence against Harry Connick and the Orleans Parish District Attorney's Office, won a $14 million judgment, which was affirmed by the Fifth Circuit and then reversed 5-4 by the United States Supreme Court. John will tell you all about the details of this case, but what remains important about it is that after Connick v. Thompson, it's very clear that civil suits, a civil remedy against prosecutors that commit the worst form of misconduct in an adversarial setting in a criminal trial, is not a realistic remedy. It is virtually impossible they have absolute immunity. And as the briefs were filed in Connick v. Thompson, our colleagues in the prosecutorial community and state attorney generals filed a number of amicus briefs saying that you don't need to have civil remedies for misconduct by prosecutors because there are other ways of addressing this problem. Internal regulation by a prosecutor's office, bar discipline, independent entities, so there could be professional discipline or actually a prosecution of prosecutors that commit the worst forms of misconduct. The problem, of course, is that as everyone, I think, involved in the American Bar Association, the criminal justice system knows, whether you're dealing with prosecutors who cross the line, or let me be the first to say it, defense attorneys who cross the line, these other institutions don't work very well. And we have to do something to make them more robust. It is a complex and difficult problem. Number one, it is not easy to distinguish between error, because we're all human and make mistakes, and real misconduct internally within a prosecutor's office, much less a public defender system. Two, once you do distinguish and you find that there is some misconduct, how is that pursued by an independent external entity? Are the bar discipline groups doing enough? Should we have an inspector general or some other kind of independent entity that pursues either a criminal prosecution or bar discipline? Why isn't that happening as much as it should be, as the data shows? Those are the questions that we're going to be looking at during this conversation. How can we make these institutions work better and deal with this issue, which is a difficult and complex one? We have with us today to discuss this issue, first of all, my colleague from Santa Clara Law School and the, I guess, the director of the Innocence Project of Northern California, Professor Kathleen Cookie-Rodolphe, who, along with Maurice Posley and others, produced a report on this issue in California that first appeared in a report of the California Commission on the Fair Administration of Justice, and now has been published as the Veritas Report. That is very important, and she will begin to address this issue. Then we will hear from John Thompson himself about his case, and then we will hear from Professor Angela Davis, who is one of the foremost authorities on this whole topic. She, at one point, ran the Public Defender Service in Washington, D.C., widely regarded as perhaps the best public defender office in the country. Don't let some of my colleagues hear that. But has also been studying this whole issue of prosecutorial error, prosecutorial misconduct, and of course sees it from the other side, having been a defense lawyer for many, many years, and has written a book, Arbitrary Justice, about this issue. We also were going to be joined today by Judge Andrew Sonner, who was a prosecutor here in the state of Maryland and is now a sitting judge and was former chair of the criminal justice section of the American Bar Association. But what happens when you invite judges sometimes to press conferences, he has real cases. And so Judge Sonner had a matter that came up unexpectedly, and he couldn't be here to join us today, but would be, I'm sure, happy to answer questions online and talk about this issue. So we have sent out notice, essentially, to our friends at the National District Attorneys Association, the American Prosecutorial Association, and a number of other organizations that have been dealing with this issue, basically to announce the beginning of this conversation. This real serious constructive dialogue on how we can deal with what is definitely a complex issue. I mean, I can tell you I've been a law professor for 34 years, and believe me, I've trained more prosecutors than I have defense lawyers, and people just make mistakes. And the question is, how do you devise institutions that distinguish between error and misconduct, and actually independent entities that can actually do something in the most serious of cases? So, having said all of this by way of introduction, I now present Professor Rodolphe.
First, let me say that the Northern California Innocence Project and Santa Clara University are really honored to be a part of this really important campaign. Prosecutorial misconduct is a dirty little secret cause of wrongful conviction. Prosecutors, we have a system where prosecutors are rewarded for winning prosecutions and considered losers when, at the end of a trial, a person is found not guilty. And we have a system where the Supreme Court refuses to hold prosecutors accountable even for repeated, deliberate, intentional misconduct. Really egregious misconduct, as you'll hear more about in the John Thompson case. While the vast majority of prosecutors do their jobs with dignity, honor, and integrity, this is not the whole picture. There's also another reality, and that is that prosecutorial misconduct occurs regularly by a small minority of prosecutors across this country. Our respect for prosecutors and the high esteem with which we hold them has also elevated them to a point now where they are really not approachable. It's very difficult to have a candid conversation with prosecutors about the problem of prosecutorial misconduct. And the result of that, I think, is that that minority of prosecutors who are committing misconduct are protected by that silence. Nothing does more to undermine the criminal justice system than a dishonest prosecutor. The Northern California Innocence Project has been studying this issue for 8 years now. It started when I served on the California Commission on the Fair Administration of Justice. We were a diverse commission set up to examine the causes of wrongful conviction to determine the extent to which they may be problems in California. My colleagues on the commission were prosecutors, law enforcement, defense attorneys, judges, and we decided that we would look at mistaken eyewitness identification, false confessions, problems with jailhouse informant testimony. But when it was suggested that we talk about prosecutorial misconduct, the group could not reach consensus that it was a problem. We really had a stalemate, we had an impasse, and we didn't have any data to inform the discussion one way or the other. And it was at that point that I started studying this issue. In 2010, we established the Veritas Initiative. The initiative is a unique national program that is dedicated to understanding and addressing prosecutorial misconduct. Our first Veritas Initiative report, entitled Preventable Error, was published in October of 2010. The Veritas report is the most comprehensive statewide review of prosecutorial misconduct in this country. It's an in-depth analysis of 14 years of California appellate cases that raised the issue of prosecutorial misconduct. That led to a review of 5,000 cases between 1997 and 2010. Recently, we published our first annual update for the cases in 2011, and we actively monitor prosecutorial misconduct cases as they are reported. While the focus of Veritas thus far has really been primarily in California, this is by no means a California problem. There were two other recent studies, one by the Innocence Project of New Orleans. They studied prosecutorial misconduct in Louisiana and really came to the same conclusions that we did. They found the same problems, as did the reporters for the USA Today who did a study of federal prosecutors. Again, they identified the same problems. So what the common problems are one, it is occurring at a rate that raises real concerns about the credibility and justice of our system. Of the cases we reviewed, the 5,000 cases, we found 800 cases where judges had actually found that prosecutors had committed misconduct. Much of it appears to be deliberate or reckless, which is actually a good thing because it means it's preventable. It can be deterred. In our study, this was an amazing fact. In our study, we found that 1/3 of all the misconduct of the number of 800 or so cases, 1/3 of those cases were committed by repeat offender prosecutors. What that means is that we found 107 prosecutors responsible for 251 of the prosecutorial misconduct cases. We found some prosecutors had committed misconduct 6 times, repeating sometimes the same misconduct without having been publicly disciplined. Accountability, huge problem, almost non-existent. In the period of years that we studied, in that first 9 years, we found that not a single prosecutor was publicly disciplined by the California State Bar. In that same period, we'd identified hundreds of cases of prosecutorial misconduct. They did cite, however, a few prosecutors for failure to pay bar dues, but not one prosecutor for their misconduct in a criminal case. Another problem is that most of what prosecutors do is unreviewable. For example, of the cases we looked at, those 800 cases, the overwhelming majority of them is error that occurred during a criminal trial. And that's obviously because criminal trials have transcripts, the proceedings are recorded, there are judges there. So why is that interesting? Well, it's interesting because in California, only 3% of cases go to trial. So what that means is that in the other 97% of the prosecutions, we really know very little. The evidence makes clear that some prosecutors are committing most of the misconduct. And they're allowed to flourish in our system because our system of prosecutors is a self-contained universe, and it protects those errant prosecutors. And we operate in a system where there is no accountability outside of that office. Problems of prosecutorial misconduct have gone unrecognized and untreated for too long. It's a problem that has to be fixed. It crosses and transcends social class, geography, and political affiliation. It devastates our communities. It's a problem for the justice system and for good prosecutors. It undercuts public trust in a justice system and confidence in the many prosecutors who are doing their jobs every day with integrity. And in this economic downturn, prosecutorial misconduct is responsible for the senseless misallocation of millions of dollars that we all know could be much better spent. And finally, there's a serious public safety issue because, as you know, for every innocent person that's wrongfully convicted, a true criminal remains free to commit more crimes. But we have reason to be hopeful. In California, we have really seen great progress as a result of our work. We are already sitting at the table, literally, with individual prosecutors, county district attorneys' offices, members of the California State Bar, and we are engaging in difficult but critically important conversations about what do we do about this problem. The State Bar is now investigating misconduct cases, and as I mentioned, in the 9 years they did not publicly address one prosecutor. In the last 6 years, there have been 7 prosecutors who have been prosecuted by the bar and have been publicly disciplined. There are other ways in which, that we've seen evidence of success, and it's very encouraging. The campaign is providing us a unique opportunity. We need to get our heads together. We need to collaborate so that we can find ways to protect innocent people from wrongful conviction, citizens from the perpetrators who remain free as a result of wrongful conviction, the system itself, and the many prosecutors who do their jobs every day with honor and integrity. Thank you very much for coming here and for your interest in publicizing this very important issue. Thank you.
Good evening. My name is John Thompson. In 1984, the World Fair came to New Orleans with Mardi Gras, which made the city go outrageous with crime. The crime rate shot to the sky. It was so bad that they had to call the National Guards in to try to help settle down with the crime. A man was killed. Mr. Ray LaLucia was murdered. The informant said I had been involved in it. This is kind of hard to even talk about because I think, I don't even believe we here standing here holding this conversation about accountability when they try to kill me. And so I'm trying to word this into a position where y'all can hear the whole story. So I'm sorry because I'm not with this. I'm with, what's need to be done. But I'm sorry. Mr. Ray LaLucia was murdered. And our informant went to Crime Stoppers and told them they knew who was involved. The police made arrests, and I was arrested for the crime. I was threatened. I was brought up on 5 more counts of armed robbery because I wouldn't confess. I was innocent. Why would I confess to something I didn't do, something I ain't had nothing to do with? So I would wind up being charged with 2 different crimes, a first-degree murder and an armed robbery. 2 different crimes, 2 different descriptions. The murder suspect was a 6 feet tall, medium-built, bald head, while the robbery suspect was 5 feet 7 with an afro bush. I was found guilty. The whole neighborhood came to my trial and seen it. Everyone knew I was never coming home again. The jury had found me guilty. They had given me the sentence of death on top of 49.5 years for a robbery. 2 felony convictions I did not commit in less than 120 days after my arrest. I was convicted of capital crimes. And to top it off, the DA asked for the death penalty. The official letter came to me when I was in my cell stating I received my final execution date. It was May the 21st, 1999. My lawyers was desperate at that time, so they brought in a new investigator, saying that they can bring in her, hoping that she come in with fresh eyes to look for anything with these last 30 days I had left to live. The new investigator did just that. She started from the very beginning. She opened up the book, and the first thing she seen was the blood request from the district attorney requesting to have my blood withdrawn. Then my lawyers started concentrating on it and called me, give me a chance to make a phone call to them. When I came out, I made a phone call. He told me he thought he found something. He didn't know what my blood type was, but he know that the victim blood type was a particular type, and it wasn't this type that was found on the scene of the crime. I was so happy I didn't know what to do because I was thinking I was gonna die. I just got fainted. I had an irregular heartbeat, And so I had never had it, checked it out, and I collapsed it on the floor. I was innocent, but now somebody finally starting to hear me. At the most, this only means that I wasn't going to be executed. It didn't have nothing to do with me still being in prison for something I didn't do. All the emotions in me with my irregular heartbeat, I just had to figure out I'm taking off that road now. I am thrown out to the world for a new trial with the same mercy. What's gonna happen? The judge, who is in that same judge in that same first trial 14 years ago, ordered the DA to turn over all of their files. Another DA from that same office took the stand and testified to the misconduct. When the judge ordered them to turn over the files from 14 years ago, this is what they found in them files. They found systematically exclusion of blacks jurors. They kept the police reports from the defense. Intentionally concealed evidence, the blood evidence. They knew that money was paid before and after each one of the persons testified. They knew 5 witnesses seen the murder, but they only revealed it one. A jury took only 15 minutes to find me not guilty when they heard all this. But for the first time, I got a chance to testify on my own behalf. I got a chance to tell my side of the story. I was only 22 years old when all this happened. I was in the jail for 2 crimes I didn't commit. At the age of 40, I'm released. And I could see some daylight. My family, the TV cameras, all was out there. They received me. And then suddenly as it appeared, I was a forgotten story. And you're wondering what happened to the original prosecutors, the men who intentionally crafted their arguments to mislead the juries, the men who checked out the physical evidence from the crime that was used and was never seen again, the men who withheld police reports that nearly costed me my life. Well, the grand jury investigation was called in this case, but the law office investigated itself. Suddenly, this case was dropped, citing statutes of limitations that ran. And then the investigating district attorney who was investigating the case resigned, citing irreconcilable differences in the Thompson case. At the end, was justice done? The system cannot check itself. It cannot correct itself. And I tell this story so it won't be forgotten. It's a criminal act what happened to me. Attempted murder, kidnapping. I don't believe you can stop naming what it is or what happened or what they did. For us to say that I should have lost my life because they accused me of murder, but yet a person could try to kill an innocent man. I could easily be Troy Davis. If I was Troy Davis, who's going to answer? Who's going to answer if I was killed? Who's going to be responsible? Who's going to tell my mother that we killed your son? Thank y'all for having this conversation. Thank y'all for bringing this conversation to y'all tables, because I think this is all our problem. This is a serious, serious issue, and I don't believe we need to give them enough power to kill us without us having to say so or something about it, to have some type of balance where we can say, if you kill an innocent man, we won't tolerate it. But right now, the court's saying we can't kill an innocent man, and we have to tolerate it. So once again, thank y'all for coming here, and hopefully this opened up the debate good enough to change what's going on in our system. Thank y'all.
Good afternoon. My name's Angela Davis. I'm a law professor at American University, Washington College of Law. I'm the former director of the DC Public Defender Service and the author of a book called Arbitrary Justice, The Power of the American Prosecutor. I'm really happy to be here today. I want to thank Barry and all of the co-sponsors for inviting me to participate in today's press conference. Prosecutors, this has been mentioned before, but they perform an important and essential role in our criminal justice system. They decide whether a person's going to be charged, what to charge them with, whether there's going to be a plea bargain, what that plea bargain will be, and they make other really important decisions at every step of our criminal process. And as they make those decisions, they exercise almost boundless discretion, unchecked discretion. They are the most powerful officials in our criminal justice system. And the combination of discretion and power can and has led to abuse. Mr. Thompson's case, the outrageous misconduct that happened there, unfortunately, there are many, many cases like his. We live in a democracy, and one of the basic tenets of a democracy is that we hold accountable. We demand accountability from those to whom we grant power, but we have not done that when it comes to prosecutors. There are mechanisms of accountability for prosecutors, but they simply do not work well. They are ineffective. Most prosecutors are elected officials. We have an electoral system. It doesn't work well primarily because prosecutors make these important decisions behind closed doors. That's the way it happens. That's the way it has to be. But because of that, the electorate is not informed. Prosecutors, when they run for office, don't talk about their charging decisions, their plea bargaining decisions. They don't talk about their policies for turning over exculpatory information. They simply don't discuss these issues. The public is not informed, and so the electoral system really is not effective in holding them accountable. It's even worse for federal prosecutors who are appointed. Very few citizens participate in that process. As Professor Rodolfo mentioned, the disciplinary system doesn't work well either for a variety of reasons. We can and must do better. It's the responsibility of prosecutors not to seek convictions, but to do justice. The United States Supreme Court says that. Those words are engraved over the door on the Justice Department. And most prosecutors believe that. They take that responsibility very seriously. And that's why it's so important that prosecutors will play a crucial role in this very important project. The forums that are going to take place across the country, and with the input and advice of prosecutors, judges, academics, and members of disciplinary committees across the country, are an important step towards meaningful reform in this area. So I just want to thank the Innocence Project, all the co-sponsors, and I especially want to thank Mr. Thompson, because Mr. Thompson, if you had decided, I think anyone would agree that after all that you went through, no one would blame you if you would just get as far away from all of this stuff as possible, as far away from the criminal justice system as possible, given what happened to you, and that you have decided to devote your life to reform of this really speaks so much about your character as a person. I'm always amazed. I've met so many, unfortunately, so many wrongfully convicted people, and I'm always amazed at how they don't harbor the anger that I hold. And these things didn't even happen to me personally, but as someone who's been involved in the criminal justice system and takes these things very seriously, it just amazes me that the people who are victims of misconduct can be so forgiving and can go on with their lives and do the work that they do. So thank you so much for what you're doing. I look forward to, I thank all of the Innocence Project, all the co-sponsors, and I look forward to supporting the project as it moves forward with its important work. Thank you.
We're now certainly available to take your questions. Just two things. In the materials we've distributed to you, please take a look at this incredible op-ed that John Thompson wrote, which I think really, as Angela said, tells you everything you need to know. Here's a man who lost this case in front of the United States Supreme Court, and honestly and truly could say, I don't care about the money, I just want to fix the problem. And that's why we're beginning this dialogue and this tour across the country to engage with our friends in the prosecutor's offices to make this system better. Also, in your materials, hot off the presses, is an article from the Yale Law Review, the Yale Online Law Journal, by David Keenan, Deborah Jane Cooper, David Leibowitz, and Tamar Lehrer, entitled "The Myth of Prosecutorial Accountability After Connick v. Thompson, Why Existing Professional Responsibility Measures Cannot Protect Against Prosecutorial Misconduct." And I think it lays out in detail and quite persuasively some of the limitations of the professional discipline process in terms of trying to redress clear acts of misconduct. One thing I will say that we know would be an extremely important reform, and if Judge Sano were here, he would certainly say this, because he, as a former prosecutor, a judge, and most importantly, a former head of the criminal justice section of the American Bar Association, and I think he actually is probably a delegate or holds quite a number of positions in the ABA and is greatly respected. One of the things that the ABA did just a few years ago is they amended the rules of professional responsibility. We have Rule 3.8, which governs ethical responsibilities of prosecutors, and there are two new provisions that are supposed to be hopefully adopted by the states. One of them, 3.8H, deals with the responsibility post-conviction to disclose credible material evidence of innocence. And then the next provision, G, G is the disclosure provision. H is the provision that says that if a prosecutor has clear and convincing evidence that somebody who has been convicted is innocent, then they ought to do something about it. Now, I think only 2 or 3 states really have adopted these provisions as written. 5 states altogether have addressed it. So we have 45 states that need to adopt 3.8 G and H. And that much we know is going to be a focus of this tour, and it's a very important reform. And we want to engage with prosecutors in the court system and bar disciplinary groups to see which are the best institutions, because we recognize that this isn't a simple problem, and that we all have to discuss it because it's an important issue that goes to the heart of public confidence in the administration of justice. So, having said all that, all of us are available for your questions, and we really welcome them.
Expand a little more on the idea that the courts aren't going to be any help in this civil suits or anything like that, and why you need some other.
Well, I think John's case illustrates this beautifully. The issue in Connick v. Thompson was that it was admitted by Harry Connick that there was no formal program or training for the disclosure of Brady material or exculpatory material within his office. And there was a finding by a jury that the blood evidence that John was talking about, that is, there was blood that was believed to have come from a perpetrator in this robbery case that was not from John, meaning he couldn't be the assailant, that was deliberately suppressed. And a jury reached that verdict, but it also reached a verdict that's what's known as a custom pattern or practice, a so-called Minnell claim. That's a Supreme Court case. But basically the jury said there was a custom pattern or practice of suppressing exculpatory evidence in this prosecutor's office. Now, the law is very clear that if one is in an adversarial situation, which usually means sometime after indictment when a prosecutor is litigating a case, that while they may commit acts which are plainly misconduct, a violation of the rules of professional responsibility, or even crimes clear subordination of perjury, obstruction of justice, all right? Even if they do that, there's no question that they, as an individual, have absolute immunity from civil suits. And there are good reasons for absolute immunity. We don't want prosecutors worrying all the time that every time they do something, they're going to be subject to a civil suit. But in order for the absolute immunity protection, or even the expansion in John's case, not even being able to get relief if you can show not just one individual prosecutor, but a custom pattern of practice in the office, if that is being severely restricted as a civil remedy, then, as all the prosecutor said in their amicus briefs before the United States Supreme Court, we don't need a civil remedy if prosecutors really will prosecute those who break the rules and commit crimes when it happens. And that would have to be, ordinarily, one would expect, an independent institution. What John Thompson's case illustrates, if you ask the same prosecutor's office to prosecute their own, it won't happen. And what about the bar discipline system? Is that really adequate? And even more, I would argue to you, because I know that there are many prosecutors across the country that are now developing what are known as conviction integrity units. These are units that will look at miscarriages of justice, but just as importantly, they will do a systematic examination internally, because it's not simple to try to distinguish between what is error and what is actually misconduct. Because you can break rules and be a young, inexperienced person, and it wasn't intentional, malevolent, or even truly a disciplinary violation. But when you have misconduct in your office, that's much more serious, and that's the significance of Professor Rodolfi's data, and maybe she would want to comment on that, because when you have, in California, a small number of prosecutors repeatedly violating the rules and being found to have committed acts of misconduct, and nothing is happening, then you know that system is broken. You want to comment on that question?
We had more questions about it. Actually, it was a finding that I was quite surprised when we set out to do this study that we would find that. I mean, really, a third of the prosecutors were responsible for, were repeat offenders among all these cases. So it was shocking, informative, and says a lot about lack of accountability, that a prosecutor can continue to commit oftentimes the exact same kind of misconduct without ever having been disciplined between actions. So there's simply no deterrence. Really, if you think about it, prosecutors have a lot of incentive to sometimes cross the line, because we value prosecutors for winning cases. And there's really no downside, because the most that's going to happen is you may lose the case may be overturned, but personally there's no consequence for the prosecutor. And so I think the nature of that structure is the source of a lot of these problems, and it's why we see so much repeated misconduct.
How do you weed out the actual instances of misconduct from the claims of misconduct? Because it is an adversarial system, and everyone wants an advantage.
Right.
And one of the ways to get an advantage is to claim misconduct.
Right.
How do you weed out the actual instances from all of the claims?
Well, first of all, the view was when we started this that prosecutors were saying, "Oh, everybody you're going to find 1 million cases because everybody complains about misconduct." And the reality was that of all prosecutions, of all appeals, there really was a very small percentage of cases where people had claimed prosecutorial misconduct. Of the 5,000 cases that we did find where that claim was raised, 800 cases, we found more than 800 cases where the courts had actually found misconduct. Now, of course, it's a systematic study. We had to be careful in our definition. So we essentially read the cases, and we put it into the column of misconduct where there was a decision that it was misconduct. Most of those were the court decided. They're all court decisions. The majority of the cases were found to be harmless error. And one of the things the prosecutor said to us upon the findings was, well, the harmless error cases don't matter. And the reality is, if those of you who are lawyers, that the decision to find something harmless error has nothing to do with the quality of the misconduct. It has to do with what the strength of the rest of the evidence is. So then I went ahead and I did a comparison between the harmful and harmless error cases, and yes, we did find that there's absolutely comparable conduct on both sides. In fact, there's some conduct in the harmful error cases that is not as bad as what we're finding in the harmless error cases. So that distinction is meaningless, which is why when we talk about misconduct, we talk about all the whole 800 cases. I think we have someone here that we want to introduce.
By the way, in terms of the practical difficulties of filing bar disciplinary complaints and being able to appeal them, that's addressed at some length in this new article from the Yale Law Journal. But it's our great privilege and pleasure to introduce Judge Sonner, and we explained that the requirements of real life and real cases sometimes get in the way of press conferences, but if you would...
I just apologize for being late. I have no prepared remarks, but I'm here very much in support of this kind of approach. I was a prosecutor for 30 years.
Andrew,
I know prosecutors all over the country. The great bulk of them are as good or better than most of the other lawyers when it comes to their behavior. But from time to time, some of them get overzealous, or some of them lack good guidance, and they make mistakes and do wrong things, just as attorneys in other fields do. I think that this kind of a study, looking at what is occurring and what can be done, will be very helpful to prosecutors. And so I apologize for being late. I just dumped my robe with my law clerk and ran out and came, but they had promised to get my docket clear by 10 o'clock so I could be here plenty of time. Then I got on the metro, and the metro is running both ways on the red line out my way, and so what would have been a 45-minute trip took an hour and 10 minutes, so I'm sorry to be late. But I do want to show my full support behind this. I've known Angela and her studies for many years and have seen what a great appreciation she takes for the practical aspects of it. Also, I haven't talked to Barry, but I saw the press release, and he recognizes what a complex problem this is. It's not something capable of a simple solution, and we really have to see how we balance in their zealous prosecutors with good behavior, and that's going to take good study and some people with good experience to be able to take a look at that. So.
Let me ask about a simple solution. Why isn't there some sort of, or couldn't you push for some sort of state laws about open records, that it would be a legal obligation of the police and prosecutors to make available all the evidence that they, because I take it the way it works now is that a lot of prosecutors and police exercise some judgment about what's material or what's, and decide, well, we don't really need to disclose all the witnesses that saw that. You know, why isn't there some sort of state law that puts the onus on prosecutors to say you must make available everything?
There are some states where there's open file discovery. I know when Judge Sonner was a prosecutor in Montgomery County, and there's open file discovery. North Carolina now, I think, has the most robust discovery laws, and it was as a result of another egregious case like Mr. Thompson's, where there was prosecutorial misconduct. And they ended up passing a law, just as you're suggesting, requiring full disclosure, and that certainly would solve a lot of the problems here. But unfortunately, that's not the case in most states. There are some states. Florida has open file discovery, North Carolina, and there's some other states. But I agree, that would resolve the problem. But there's a great deal of resistance from some prosecutors for such a law. The other thing I wanted to say, and I apologize that I have to leave to teach a class, but before I go, I wanted to say that one of the reasons why the disciplinary process has not worked very well is because speaking as the former director of a public defender office, when defenders and defense attorneys work day to day with prosecutors, they're very hesitant to refer prosecutors to bar counsel, even when they're well aware of misconduct, for some pretty obvious reasons. You have to work with that prosecutor's office. You've got to work with them with future clients. You've got to get plea offers, and and they have a great deal of discretion. They don't have to give plea offers. They don't have to work with you. And if you start referring them to bar counsel, then there's an obvious problem. So I understand why a lot of defenders are hesitant, particularly if they work with them from day to day. I'm not so sure why more judges do not refer prosecutors, especially when they make a finding of prosecutorial misconduct on the record. There are some judges who have done it. You know, Judge Emmett Sullivan did it in the Ted Stevens case and in other cases, but very few judges do it as well. And I think that's also a huge problem that needs to be addressed. But I do think that this project is going to make some progress towards addressing these issues, and I apologize for having to leave.
That's actually one of the incredible findings in Cookie's study is that in California, when an act of misconduct led to a reversal of conviction, it was the law that judges were mandated to refer it to the state bar, and none were referred during the 10-year period. Judges didn't even seem to know that that was their obligation. But this is a terrific question that goes to the heart of what is so hard about this issue. Maybe it shouldn't be. Yes, go ahead.
Just that, you know, one of the good things they said was reasonably hopeful. On that particular issue, Chief Judge Ron George, when he learned that they were not complying with this obligation that they had, really took them on. And now there's actually a whole segment in the judicial training. When judges are trained, they're basically very explicitly told this is your obligation, and we're seeing a lot more of it. So it's, you know, it's working.
But it took this project to bring that change in California. One of the issues, though, that you raised directly with your question are, A, what about discovery laws, right? I mean, there should be statutes and it should be clear processes in place so that there are these open file procedures. And listen, nobody is suggesting for a minute that if there is a danger to a witness, that there are not processes in place that prosecutors can use to time the disclosure of the material with the cooperation of the judge. And, you know, this is very jurisdiction specific, because you will find many prosecutors, even though statutes don't require it, who say, I have an open file policy. If there's any doubt in my mind as to whether something is exculpatory, the best way to solve it is just turn it over, although we take precautions to protect witnesses. That's one whole approach. The Judge Wolf, federal judge in Boston, who had a number of controversial cases, set up on his own a system in the federal system up there where there has to be a conference before the trial, just before the trial, where the prosecutors are told, you must look through your materials, you must make sure that you've looked at everything that could be exculpatory evidence. We had a conference on disclosure of exculpatory evidence at the Cardozo Law School, and published a whole issue of our law review where we brought in people from the medical community and cognitive scientists on how to get at this problem. And Atul Gawande, the surgeon who wrote that great book, The Checklist Manifesto, we drew upon some of that work, you know, to suggest ways that checklists could be created so people could be assisted in doing their jobs and making sure that exculpatory evidence was disclosed. And I know that in a conviction integrity unit in New York City that the newly elected district attorney Cy Vance has just set up, that these kinds of checklists are being used, and that there are conviction integrity units in Dallas, in Houston, in Santa Clara, in other offices across the country, and there will be a conference soon at New York University Law School by one of the sponsors of this program, Rachel and Tony Barkow, who are professors there, who are going to be looking at this issue in a creative way. So there are, we have to, it's not simple because, frankly, the rule, the so-called Brady rule of the United States Supreme Court is a kind of nutty one, and that is that something is considered Brady material that should have been disclosed, right, only after there's been a conviction. So basically a prosecutor has to look at this material and say, aha, well, I have to disclose it only if, after a conviction, an appellate court would decide that this was material and important, and there wouldn't have been a conviction if I hadn't disclosed it, right? as opposed to simply looking at the material. And there have been a number of proposed rules, ethics rules by many, that maybe it should just be a judgment. Is this favorable? From an objective point of view, is it reasonably likely that this is favorable? And then there should be disclosure. But these are exactly the kinds of questions that we hope as we go across the country, because we're going to get prosecutors, ethics professors, law professors, as well as John Thompson, who will be at each one of these meetings, and people from the community to come together and talk about what's going on in this state and other states in the region, and what can we do to change it. Tim?
You're speaking generically about prosecutorial misconduct, which can cover a broad field, but here we're talking about Brady violations, Mr. Thompson's case, Brady violations. That seems to be the big one. Now, what percentage of these misconduct cases involve Brady?
Cookie, you want to take that?
I don't have that history with me. It's a significant number, but there is so much other kinds of misconduct. So many other cases we have misconduct, but I wouldn't say it's the majority of it. It certainly isn't serious.
When you look at the percentages, in terms of what cases get reversed, suppression of exculpatory evidence is the leading issue, although there's plenty of instances that involve improper closing arguments, right? That happens repeatedly. But the Brady issue, of course, is, in some respects the most serious one, because we're talking there about evidence of innocence, and this is what usually is at issue in the cases where after a conviction we find out somebody's innocent. And that's why I bring up again, the ABA has already spoken on this issue with the amendments to 3.8. So maybe people make mistakes during the course of the trial, or evidence is not disclosed, it's exculpatory. But after a conviction, that's really where the problem lies, because it's not clear to what extent the Constitution requires much disclosure post-conviction. So that's why the ethical rules are of even greater importance now. And when you have the American Bar Association saying something pretty simple in a way, and that is, if post-conviction there's material and credible evidence of innocence, that should be disclosed as an ethical matter. And if you have clear and convincing evidence that somebody's innocent, you should do something about it. And those rules have not been adopted by the vast majority of states in this country. And all of us who have been involved in this ABA work, maybe Judge Sonner can speak to this, would really like to see that happen. And that is one of the primary purposes of this tour, to find out why that isn't happening and how we can bring it about.
Well, yeah, I would just echo the ethical problems involved in closing argument, opening statement, and a number of other things where supposedly the law can cure by asking the jury to disregard those improper remarks from the prosecutor. They shouldn't be made to begin with. But what I would say is I went down to North Carolina in connection with a consulting job that I was doing for American University. And we met with the North Carolina prosecutors, and they are happy to live with the statute, which is as broad as any discovery rule anywhere in the United States. And it is not causing them problems. The prosecutors who say that it will cause them problems are wrong. There's another area that the prosecutors sometimes are kept from information themselves. Now that's happened in my jurisdiction, and where the police on their own decide that they've got the proper person, and they do not want to turn the information over to the prosecutor. So it seems to me it has to go further. The prosecutor really has an affirmative duty to go to the police and make sure that they tell him all about the case, not just enough to go to the grand jury and to get a conviction. And I think that a study of that kind of behavior on the part of prosecutors would be helpful too.
What portion of misconduct cases that end in conviction involve some lack of effort or duty on the part of the defense bar in terms of cases that could have been mitigated if you had a attorney who was
Very
Yeah, I feel very strongly about this, and nothing convicts an innocent person faster than a defense lawyer that's not adequately doing his or her job, period. And a lot of the problems that we have in this system is that when the defense function is not adequately funded or vigorous, the system implodes on itself because it is the vigorous defense lawyer representing even somebody who is guilty, not just the innocent, who will expose a prosecutor who breaks the rules, who will expose a crime lab, for example, that's not doing its job. I mean, we, the Innocence Project, have been involved in exonerating innocent people and then discovering that crime labs were not even doing the tests. So Fred Zane in West Virginia was running a crime lab there, and they were dry labbing it, quote unquote. They were just producing results for more than a decade and not even doing the tests or getting incomplete results. Houston Police Department Crime Lab was audited by Michael Bromwich, the most comprehensive audit in the history of our country of a crime lab, and he also audited the FBI, if you recall. He's now dealing with the British Petroleum spill in the Gulf for the Justice Department. He was an Inspector General in the Department of Justice. But there were 80% of the cases that in serology cases in the Houston Police Department Crime Lab were deficient, it was found in a reevaluation. And so it goes across the country. Joyce Gilchrist in Oklahoma City, Joseph Sirwick in Cleveland, Ohio. And I could go on and name them. So, you know, it's of course important that the crime lab officials weren't doing any quality assurance or meaningful supervision. But what about the defense lawyers? You know, if you're not doing your job, you don't expose it, okay? And so I think it is a serious problem that the defense is inadequate, and it's not a real adversarial system because without funding, without adequate resources, without meaningful standards of effective assistance of counsel, the whole system implodes. And I should say that, we have a problem, obviously, with bad closing arguments by prosecutors, but sometimes there's improper defense arguments that induces improper comments by prosecutors, and it hurts the whole system. Maybe if the defense was more vigorous, they might find some of this evidence that was otherwise hidden. So yes, the defense function, is certainly something that we have to look at. And the fact is that trying to determine within an office whether you have proper internal management systems to distinguish between error and misconduct is not simple. And so we are in this iteration of our examination going across the country and asking our prosecutorial colleagues to set these systems up, right? Which is not to say that at a later time, and based on some insights we're going to get as we do this tour over the next year, we have to turn to the defense function and ask the same questions about the defense, although it's not a perfectly symmetrical set of responsibilities or roles. Those are still important questions, and we hope to learn a lot from this first tour and go back and revisit those other questions. Well, and of course deal with them, just as you asked this question at the press conference, it's going to be asked as we go and do this in law schools, and will be addressed, and we'll get more insight into it.
On this question of the role of defense counsel, Barry's completely right. Defense counsel has obligations which too often fail. But on the issue of prosecutorial misconduct, it's a particular problem because objecting to prosecutorial misconduct has to be done in a very particular way. And what we find is that we found so many cases where the issue was waived. So even though the issue was raised, the court decides they're not going to get to it at all. And that's because they find that the defense attorney did not jump through all the hoops and take the exact right steps in properly objecting to the misconduct. They have to object, and have to ask for a curative instruction. Oftentimes the curative instruction is given by a court, but of course by then the cat's out of the bag. It's complicated. But I think it's much more difficult to effectively object in these cases. I also want to say that, I think in some ways prosecutors have a very unusual point of view on this stuff. They have a very hard time acknowledging their role in this. And one example I have is that in one of our cases, I got a phone call from a prosecutor. Well, one of the things what we did was we posted on a website the names of the prosecutors who were found to have committed harmful error. So I got a lot of calls from prosecutors saying, would you reconsider my case? Which was quite interesting, really, to be in that position. But of course we did. We always did. And in some instances we agreed with them and we would take we would say, we would reverse our finding. But one of the calls I got was from a prosecutor who complained that he was listed as having committed misconduct, but in fact the case had not been decided based on prosecutorial misconduct. So like I always do, I said, okay, we'll get back to you. I found the case and read the case, and the interesting thing was that, no, the case had been decided based on ineffective assistance of defense counsel. And the basis for that decision was because that defense counsel had failed to object to the repeated misconduct by the prosecutor throughout the trial. And that prosecutor had the sense that it would be okay to call and complain about that. That to me reflects a certain culture, manner of thinking that is a big part of our problem.
One other quick, most of us cover the Supreme Court. The court has taken an interest in this subject, not with outcomes that you like, but an interest. And one constant in this is the Justice Department's view that prosecutors must have complete immunity all the time. And they've taken a very hard line. I wonder if you had any discussions with the Justice Department about these issues.
Well, there have been some discussions with the Justice Department about these issues and the Office of Professional Responsibility and how they handle them. It should be said that the Supreme Court did also decide the Goldstein case 2 terms ago, and that was a case where there was an allegation, again, another Minnell claim, and also an individual claim that there was not a process in place in Los Angeles to supervise the use of jailhouse snitches. So basically, in Goldstein's case, the jailhouse snitch had a deal with one prosecutor in Los Angeles County Prosecutor's Office, and the one that was doing the case with Goldstein didn't know there was a deal, and therefore it was not elicited, and that was error that was eventually discovered, and Goldstein did a lot of time in prison. And the Supreme Court said that is not the failure to have that kind of system in place, even though you might characterize it in some ways as administrative, or at least the plaintiffs thought it would be administrative. The Supreme Court said, no, that's still within the adversarial function, and you can't bring a Minnell claim on that basis, or an individual claim against John Vandekamp. Again, what that means, right? The Goldstein decision, the Connick v. Thompson decision is the reason that we have to have this tour, and we have to go back and look at these other institutions. Is there really an independent entity out there, and we think maybe look at inspector generals as a model, which once you have identified misconduct will really result in the prosecution of a prosecutor or a professional discipline? Are those systems working well? I think it's self-evident that they aren't, unfortunately. And what about the internal workings of a prosecutor's office? I think that this in many ways is the most interesting question, because Cookie will be the first to tell you that, and I think it was a question that was asked before by Mr. O'Brien about Brady material. We really don't know the depth of this issue. I will be the first to tell you that a lot of times that it's suppressed exculpatory evidence that prosecutors don't turn over, it's the police have hidden it from them and they don't know about it, right? So that may be a reversal for a suppression of Brady material, but it's not the fault of the prosecutor. The Goldstein case is a perfect example in terms of the individual prosecutor. But then you have to ask, what kind of internal systems are in place within an office to distinguish between error and misconduct? Because my colleagues, when we talk about this in the American Bar Association or within the Academy, are always saying, look, You've got to distinguish between error and misconduct, and just don't go around this country pillorying prosecutors and giving the impression that what happened in John Thompson's case is happening across the board in an epidemic. And that's plainly a fair point. It's not true. We're not saying that. But what we are saying is that we really have to look at these institutions. Nobody can be better at distinguishing between error and misconduct if you have a serious internal system in place than a prosecutor's office itself. And the same will be true eventually, you know, when the defense begins looking at it seriously as well. And so that is the challenge. We're saying, look at the internal systems, distinguish between error and misconduct. If you find misconduct, you have adequate independent institutions to either discipline people professionally or prosecute them when it's criminal. And what about 3.8, changing the rules? And these are all possible solutions. And if none of these work, maybe you ought to take another look at civil remedies. What's wrong with the civil remedy if you intentionally convict an innocent person as a prosecutor? Can you narrowly craft a civil remedy for that? Now, I'm not saying that that's the world's greatest solution, but if all these other institutions are failing, maybe you have to revert back to that. That's the kind of conversation that we want, and we want, and we're really going to reach out to our prosecutorial colleagues in each of these different jurisdictions to find out what's actually happening on the ground and what we can do together to make this system work better. You want to say something, Andy?
I would just say that the time that Imler versus Packman came down, I was very active with the National District Attorneys Association, and John Vandekamp was the district attorney for the County of Los Angeles with over 1,000 employees, and for them to have applied the doctrine of respondeat superior to him meant that he was going to be held liable. And if you know John Vandekamp, he comes from Van Camp's Beans. He's independently wealthy and had substantial exposure. Now, it seems to me that the remedy of a civil suit with holding the elected prosecutor responsible for all of his employees underneath, it would be a very, very difficult for many prosecutors. It might discourage many from going into it. So that's when this decision came down, and now we're going to look for other ways other than using the civil suits. And I would maybe want to make an exception for anybody who intentionally convicts somebody as a prosecutor who's innocent. It seems to me they ought to make him serve the time. That's a serious violation. I don't know any prosecutors who have done anything like that, but if they ever did, it seems to me they ought to be liable. But I was hopeful that we would be able to develop the set of procedures that would be guidance within offices for setting up. The other Supreme Court case is Giles versus Maryland, which was the case in which the prosecutor was lied to there by his police officers. And he went forth as a very vigorous prosecutor, convicted 3 people, and they got the death penalty. They were eventually freed, but in any event, it was the prosecutor who was lied to by the police. I think that he should have had some kinds of procedures that would have been helpful to keep the police from lying to him, make sure they got all the information.
Yeah, we should say this about John Vandekamp. John Vandekamp was the chair of the California Commission on the Fair Administration of Justice that commissioned Professor Rodolfi's report, and he is truly a great man of the bar. And if everybody listened to John Vandekamp about how to deal with these problems, we'd all be way ahead. So I mentioned his name because it was the name of the lawsuit, not because of any particular bad feelings towards John, not in the least.
In the 6 states that we are planning to visit in the forums as part of this campaign, we are going to be doing independent research in each of those states. It's not going to be as extensive as what we did in California, but we will be doing individual research in all those states so that when we come to the table, we'll have really specific information about the locations of the conversations are better informed.
Yeah, and 2 other things I should mention because you raised it in the question about the United States Supreme Court. The United States Supreme Court did take a really interesting case that's going to be argued in, I think, the next week or 2, called Smith versus Kane. And this arises again out of Orleans Parish and deals with the issue of suppression of exculpatory evidence. And many of us reading the tea leaves think, maybe they took that case because of John Thompson's case, which is not to say that on the merits of this, there are extraordinarily serious and important issues dealing with the suppression of exculpatory evidence. And when you read the merits brief and look at the testimony of the hearing, you know, the issue before the court is, should the conviction be reversed based on the apparent exculpatory evidence that was not disclosed? The question of who was responsible for that, right? When you read the record, it's the question has to be asked, well, did the prosecutors know about a lot of this? I mean, an inference from the record is apparently so, but you know, that I'm sure will be worked out in the courts. I don't want to officially comment on that, but it's certainly an issue in the case. Nothing else? And the last thing I should say, and I can't really comment about it, but some of you are going to be seeing it soon, is that there is quite an extraordinary prosecutorial misconduct case, or allegations of it, I should say, in our court papers arising in Texas now of a defendant that was wrongfully convicted named Michael Morton, and the prosecutor who was in charge of that case, I was told before we walked into the room that the Texas Court of Criminal Appeals denied his motion to quash, and I'll be deposing him on Monday. So stay tuned, watch for that one.
Thank you all for your interest in this.
How many does that come out of?